Well, we talked a little bit about Janet Parks. I mean, one of the first things I wanted to ask you is, this is the 40th anniversary of Title IX, and you were involved in sport on campus. So could you tell me a little bit about how you first became involved and how female athletes were treated on campus at that time?
Sure. You know, I came to Bowling Green from a small town in Ohio, McClure, Ohio, and there were no sports programs for women, none whatsoever. No matter how talented the young woman might be, nothing. And then I came to Bowling Green, and at Bowling Green, as I say, when I look back on the experiences in my life, Bowling Green has a special place, because not only was it an intellectual awakening for me with almost endless variety of intellectual challenges and ability to gain knowledge, but it was also an ability for me to develop my physical abilities. And so I became involved in sports and intercollegiate sports. And as you say, at that time there was no Title IX, and we had women who were the coaches and the assistants. And we did get some assistance from the school. Sometimes we could use transportation from the school. Of course, we used equipment that they had. And I remember once in basketball spraining my ankle quite badly, but we were allowed to use the men's physiotherapy facilities so that I could get better quickly and play. But it was just sort of a nice little thing that girls do. And then Title IX came in, and what a difference it has made. And just beyond being able to develop your physical abilities and your physical skills, I think sports and organized sports are so important for girls and women, because they teach you that you really can compete on the fields of friendly strife and still be friends afterward. And they also teach you about competitiveness. And for some of these sports, I think now Bowling Green has rugby, and I played rugby later in my life. They teach you that you're not this fragile little thing, that you are a person who can be strong and resourceful. And so it gives you a lot of self-confidence in ways that boys and men have always known that it did. And it allows you to build networks. I think it is still not so much the case with women that they build business networks through sports, but men certainly have done that forever, and it's a good thing. So Title IX brought a great richness to women's lives who went to university, I think.
Mm-hmm. I mean, obviously Title IX does lots of other things too related to education, but I mean, just knowing that you were a standout athlete's pretty significant.
Well, I don't know about standout, but I certainly was an athlete.
When you look back at BG, we're talking about sport obviously, but when you look back at your whole experience at BG, what do you think was the best part of being a student there? What did you take away that you might not have if you'd gone somewhere else?
Well, you know, I was fortunate in that the year that I began at Bowling Green, I think, was the year that they introduced the honors program. So I had the benefit of smaller classes with more discussion, more interaction, and I found that to be very rewarding. But what I really took away from Bowling Green, I think, was that the idea of Renaissance man or woman is a very good idea, where you develop yourself in many, many areas, in the humanities, also to some degree in the sciences, or to a greater degree in the sciences, but that you also develop your physical potential. And I took away from Bowling Green a lot of knowledge, of course, increased self-confidence, I think, in many areas, and an expectation that I would do what I believed was played to my strengths and my interests, regardless of whether others thought that was appropriate for a woman or someone from my background or not.
Mm-hmm. Did, when you were a student, what sort of work did you expect you'd be doing when you graduated?
You know, I went to university to just take the benefit of all these wonderful courses, and I would go into the bookstore before classes began and buy textbooks for courses I wasn't going to take. So I must say that I really had no idea what I was going to do when I left university, because I chose the subjects I was interested in while I was there. And I have been fortunate in my life in that I have been in the right place at the right time to do quite a few different, very interesting things. But I must say, not because of any great pre-planning on my part.
I've read that your sister originally urged you to join the military, as she had done.
That's correct.
Could you talk a little bit about that and what that was like at the time?
Yeah. My sister is almost 5 years younger than I. And she was in the military as an enlisted woman. Many people in our country, in our family, had been in the military, mostly as enlisted. And I had graduated with a Bachelor of Arts degree in many, many subjects that were very interesting but didn't really get you a job. So I became a Peace Corps volunteer in West Africa as a public health worker. Came back, went back to university for a while, and really had no idea what I wanted to do. And my sister said, you know, I think that you might enjoy a career in the military. And my sister had been in the Air Force. And she said, I've talked to a recruiter who says that he thinks that you would be qualified as an officer in the military. So I thought, well, you know, sounds interesting. My family have been in the military. So I interviewed with the recruiter and entered the military as an intelligence officer, not a covert intelligence, but a briefing officer for air crews. And that was my first exposure to Colorado, because I trained there in intel school. And went home on leave with orders to go to Vietnam, which I had volunteered for. And came back to find that my orders were on hold because there was a regulation that if you had been in the Peace Corps, you could not serve in an intelligence function in the military unless there was a certain number of years gap. And so there were 2 or 3 of us actually in my intelligence class that had been in the Peace Corps. So we were all put on hold. So I spent about a year trying to get a waiver for that. Eventually did get a waiver, but in my view, very unfortunately for me, I no longer was able to have an assignment to Vietnam. I was sent to Thailand. So I was in Thailand for a year. And then, so that was how I got involved in the military, and that was my early military career. And then when the conflict in Vietnam, when we withdrew from it, we had a lot of intelligence officers, briefing officers. And so I accepted the opportunity to come off active duty, but not resign my commission, and went into the reserves and went back to Denver, Colorado, because I fell in love with Colorado. And I couldn't get a job. I mean, what was my background? I had a Bachelor of Arts. I'd been a Peace Corps volunteer public health worker, and I'd been an intelligence briefing officer. And at this time, many, many people were flooding to Colorado and to Denver. They had masters, they had PhDs. So I couldn't find a job that I wanted. And someone that I played sports with said, you know, they're giving this law school admission test. You ought to think about that. So I signed up at the last minute, took it, and I did well enough to get a slot at the University of Denver. And that was really what I wanted. I didn't want to leave Denver. So that's how I went to law school, because I couldn't get a job, basically. So I went to law school. And then in law school, we had a lot of people from the military who were there, either had been given leave from their other duties and were paying their way through, or were funded by the military. Some of them were Air Force, and convinced me to go back to the recruiter and talk about going back in. So I did. And when I graduated from law school and passed the bar, I went back into the Air Force as a judge advocate.
Was that the plan when you were in law school?
No. I went to law school because I couldn't find a job. So it was something to do for 3 years, and then let's see what would happen after that. I must say I'm not a good role model for people who believe that you have to plan your life out, because my plans have been more short-term and really have revolved around what interested me at the time. But I think also when you do plan your life out, you have to factor in that your interests may change as your life moves on, and you may find that you have skills in areas other than those you had planned. So flexibility is the key to air power in the Air Force, and it's also a good motto for life.
You had mentioned that you were in the right place at the right time, and it was funny because when I was looking into the Yugoslavia tribunals, it seemed that you were obviously one of the the team that was out there as part of that. Where were you in your career? Can you talk a little bit about what had happened between law school and the time that you found yourself?
Sure. I was in the Air Force. I had spent most of my JAG career as a prosecutor, either at the trial level or the appellate level, or being an interim head of our trial and appellate division for the prosecution in Washington, D.C. And I was coming up for promotion to full colonel. And so within the JAG Corps in the Air Force, we're very fortunate because we have a very involved career management group who work with us to ensure that each member in the JAG Corps can really reach his or her potential. And so I was told, if you want to have a chance to be promoted to full colonel, you have to avoid the 2 C's, criminal law and Colorado. So they gave me a job as the staff judge advocate at Rhein-Main Air Base, which shares the runway with Frankfurt International Airport. And I was there actually when they began to, when they created the Yugoslav court and when they began to put people into positions there. And the Office of the Prosecutor was having difficulty getting experienced people in, so it can be a drawn-out process for recruitment and staffing in the United Nations. So the United States said, we will loan you, I think it was 21 or so people who are either prosecuting attorneys, investigators, and I think there were a few from the State Department. And the Judge Advocate General of the Air Force picked me as one of the ones that they would nominate to be loaned to the Office of the Prosecutor at the Yugoslav court. I was among those who were selected. And so I just basically drove up the road from Frankfurt, Germany to The Hague in the summer of 1994. So I was very fortunate. Again, it was timing that this re-emergence of criminal accountability at the international level occurred at a time when I had the experience to help it, at a time when they needed people, and at a time when the United States government said, we'll loan you some people. So I was there really from virtually the beginning of the development of how the Office of the Prosecutor would approach these crimes. What would we say the elements were? What would we say procedures were? How would we interpret our responsibilities under this new statute and these rules of procedure? So it really was timing. It was a confluence of events that took me to The Hague.
When you were a judge advocate before the Yugoslav tribunals, what sort of things were you doing? I mean, people you see, on television and in movies, what your idea of military court is.
Don't believe most of that. But in the United States military, of course, judge advocates are commissioned officers. We are combatants. We are eligible for command, unlike in some countries where they are not actually members of the military. They're not military officers. But we also have jurisdiction over not just military crimes, but the entire spectrum of crimes. Mm-hmm. And so, as a prosecutor, I was involved in everything from drug crimes to child abuse to murder to rape to crimes of theft. So it was the entire gamut of crimes, plus purely military crimes. And of course, part of what we did in some of my jobs in the Air Force was to train people in the law of armed conflict. And we ourselves received training in the law of armed conflict.
So who would the accused be if you were doing a case related to child abuse or theft? Was it always
military members?
Okay.
We had the Uniform Code of Military Justice gives the criminal justice system in the military jurisdiction over 2 categories of people. One, most obvious, military members. on active duty, and in some circumstances, members of the reserve. And then there's also a provision that I think could have been used more to bring accountability to the actions of some of our contractors in Iraq and other countries, and that is that under the Uniform Code of Military Justice, the military courts can also have jurisdiction over civilians accompanying the force. And had I been in a position to be making these arguments, I would have argued that these people are civilians accompanying the force, and I would have done everything I could to bring them under the jurisdiction of the Uniform Code of Military Justice, because otherwise there's a big hole in accountability out there.
That's really interesting, especially, I mean, you hear so much about that now with so many contractors over there. So Greg, I had some questions about the Yugoslavia. I don't know, I mean, at whatever point you want to jump in, you can interrupt me or whatever. So when you first, so you're over, you're preparing for the Yugoslav tribunals. I read that you interviewed victims. Tell me about what preparations were like. I mean, who was doing who was interacting with victims, and just sort of what was that?
Sure.
What was that like?
Unlike a lot of the national systems, you don't have a separate police investigative function and a prosecutor function. It's the Office of the Prosecutor, and investigators are in the Office of the Prosecutor. And also, unlike a lot of the domestic crimes, these crimes are very complex, and they're not, I mean, when we began in 1994, we were looking at what are the real elements, what do we have to prove in court. So they're very complex, and you need a mix of investigators and attorneys and analysts from the very beginning. And that's how at the Yugoslav court initially we were set up as prosecution section, investigative section, but within the investigative section you had legal officers assigned to investigative teams, you had analysts. And I have always enjoyed field work, always. Mm-hmm. And so I was motivated to go on these missions. Plus, I truly believe that you need to have attorneys on these missions so that you can be sure you're gathering the right sort of information and try to be as comprehensive in your interviews as possible. So for the first, I got there in July of '94. I went into Bosnia for the first time in August of '94 when we were looking at setting up our missions there. And it was a very hot war in Bosnia at that time. But we began then going out on field missions in September of '94 into Bosnia. And I went on those missions. And so I would be involved in these interviews. We would always be sure we had an investigator or more than one investigator so that if any issues came up, they could testify in court. But I was involved in the missions and the interviews of these victims and survivors from the very beginning. Mm-hmm. And it, you have to be almost bordering on, shall I say, schizophrenic to be an investigator or a prosecutor in this scenario, because you are dealing with people who, in our case in Yugoslavia, in the summer, fall of 1994, were giving details about their experiences, some of them for the very first time. And so there was a very human element here, just the horrific suffering that they themselves had experienced or that they had experienced secondhand by having to go out and find members of their family who had been killed in horrible ways, bury them, stand by as members of their family were killed. So there's a very human dimension, and you cannot help but react as a human being to this human dimension. But at the same time, part of you has to stand back and evaluate this in terms of, is this relevant to what I need at trial? Does this person come across as a credible person? Do I need to cross-check this? It may have happened. It is horrific, but it's not beyond the realm of possibility. So you have to be very objective at the same time that the humanity in you is reacting to the anguish that you are seeing before you. So it certainly broadens your perspective. but it also, I think, instills in you a very real understanding of how horrific these crimes are. And any violent crime is horrific for the victim, whether it's one victim or 10,000 victims. But when you see the story repeated 1,000 times, 2,000 times, 10,000 times, Rwanda, 800,000 to 1.2 million, depending, the sheer scale of it and the viciousness of it and the lifetime impact on those who survive becomes very real to you because you're dealing with it firsthand. And you also become very aware that when this type of crime happens on this scale, these societies emerging from this kind of prolonged criminal victimization have so many needs. One of the needs is accountability for what has been done to them, and I think that's a human need. If we have been wronged, we want some form of accountability. And you also begin to realize that at least for certain crimes, certain levels of viciousness, and for certain levels of perpetrators, that accountability has to be criminal. And sometimes it has to be at an international court. But that is one aspect of one need. And these other needs have to be met as well. Very real medical needs, counseling needs, economic needs. Often the entire country is impacted by these crimes. The infrastructure is destroyed. There has been a mass exodus of the professionals in that country, so you don't have teachers, you don't have doctors, you don't have nurses. They've all fled because they would be primary targets. And so there are so many needs that need to be addressed, and they each have different programs that are needed to address them. But because the courts are often very visible in these countries and more visible than any other response, the courts very often have been judged on how well they meet these other needs that have nothing to do with our mandate or our resources. So there have been criticisms of these courts that have nothing to do with what we are there to do, what we are resourced to do, what we're mandated to do. And so there has to be a sort of a coordinated, complex approach and response to these situations. And our courts are just one part of one response.
This is kind of a minor question, but what would compel a victim to talk to you? Were they required to talk to you? How did you get people to tell you their story? I'm sure some were afraid to do so.
Well, when you start out with an investigation, you have some names, and they may be people who are what I would call a sort of an overview witness, and that is a person in a position to have traveled in an area, to have met victims, maybe a doctor at a hospital where many victims were brought. And so you can begin to get names of people at that level. You interview them if they're willing. Mm-hmm. And then they will tell you the names of some people. And then you have indirect contacts to see if these people are willing to speak with you. And we tend to think of victims as very weak people who are very timid and shy. They're actually incredibly resilient and incredibly courageous. And so we would begin with people who were willing to speak with us. And at the beginning of the interviews, we would explain who we were, why we were there, and the consequences to them of talking to us. Because it could be that we would decide we did not need to use them, but if they told us something that would assist the accused to perhaps show that he wasn't guilty or to lessen his guilt, then we would have an obligation to turn that over. Or we would have to take other measures to ensure that the accused had the benefit of this exculpatory evidence. So we felt that before people told us anything, they needed to understand the full consequence of speaking with us. Because one of the things that happens when you're a victim is that your ability to make choices about yourself is taken away from you. And so we wanted to give that back to them, and we felt that that was a basic human right. So we would explain who we were, why we were there, and how the information could be used. And then if they agreed to speak with us, they were very willing to talk with us. And if they had not spoken in detail before, you would sort of get almost an eruptive effect where all of this that was bottled up inside them would just come out. And you would have to wait for that to subside to go back to start shaping what they had to tell you into the little categories that were relevant to you. And so then you would speak with them. But we never, if it was a person who was a victim or a survivor, we would not force them to come forward. We would certainly try to convince them to come forward. And if they had security concerns, we would talk to them about our ability to request protective measures. And then we could work to file motions to get protective measures for them. But I've always been struck by the courage of the victims. And later in the Yugoslav court, with us in the Special Court for Sierra Leone, we actually got as witnesses people who had been members of perpetrator groups. And they were willing to come forward, and many of them to acknowledge their own criminal conduct, but to build those links between the direct perpetrators, those who raped, maimed, killed, enslaved, and those in the higher chain of command who may have or may not have been a direct perpetrator, but had other forms of responsibility. They ordered, they planned, they aided and abetted. So they gave us the links, although some victims could as well, because some victims had been held in camps where higher level offenders came to the camps. Some of them even knew them because some of the people held in the camps had been people of influence in their community. Or they would learn the names because they had been held captive for years. So victims to some degree gave you that, but certainly the insiders gave you the broader picture. And in many ways, it was even more courageous of them to come forward because not only do they have to admit to what they've done, which is not easy for any of us, but they are considered traitors to their group. So you have victims who are testifying against perpetrators, and they are at risk if they live among perpetrators or supporters. But those who are considered not just as bringing perhaps the most damning evidence against these accused, but who are members of that group are really seen as particularly worthy of retaliation. So they were even more at risk to come forward.
That's interesting. What do you think, we talk about rape being classified as torture for the very first time, what do you think was the most significant result of the tribunals overall?
I don't think there is a most significant result. I think if it would have to be very broad. And what I would think is the most significant result is the development of all of this jurisprudence, so that now we have put flesh to the bones in a modern setting where procedural rights have developed. We have put flesh to the bones again of these international crimes. When we talk about genocide, what does it mean to say that you have the intent to destroy a protected group in whole or in part? What does the in part mean? When we talk about the various forms for genocide, how do you define those terms? How do you flesh them out? And what the ICTY and the ICTR, predominantly them, also the special court, has done is has developed a body of jurisprudence that says when we talk about genocide, here's how we define the terms. Here's the parameters of those terms. Here's how we define the intent requirements. Here's the parameters of that. Here's how we actually, in a real court setting, have determined what are the fundamental rights of an accused. What happens if an accused doesn't want to be in trial that day, or if they escape afterward? What happens, what is the boundary of a fair trial to the accused? Because we have to balance that, of course. You have to give them a fair trial, but that has to be defined in terms of protection for witnesses, of orderly proceedings. So they have put flesh to the skeleton so that now we truly understand what these crimes are, and procedurally, how do we go about actually bringing these huge, when we talk about thousands, tens of thousands, hundreds of thousands of victims, crimes, tens of thousands of perpetrators, years of atrocities, how do you bring it all together? And so these courts have basically provided a way to do that, and the jurisprudence of the court has memorialized the way to do that.
What was there anything particularly shocking that victims told you? Was there anything, especially at that stage in your career, that you were surprised to hear about, or?
I wouldn't say surprised to hear about. I had prosecuted criminal cases in the Air Force. Violent crimes, sickeningly violent crimes against accused own children. So I think it was the scale of it. And some of the things were almost Machiavellian. They were in terms of the evilness of it. For example, we interviewed a witness who had been held in one of the camps, and he told us that one of the things that his captors made him do is they would bring him into a room, they would put him at a table, sitting at a table. They would put before him a glass of alcohol and a cigarette. He wasn't allowed to have them, but they would put them in front of him. And then they would bring in another detainee, and they would question and torture that detainee in front of him. Now, he had to watch someone being maltreated in this way, and they the whole time were looking at him thinking that he was a traitor. Now, if you think about the psychological implications of that, it's very, very, it's very intricate. It's very subtle, but it's devastating. It's devastating for the person that they're trying to break down, and it's devastating for the person they're using to try to break down the other, and it also breaks them down. Or many of the sexual violence crimes were committed either in sight or hearing of family members, villagers who knew these people. And so it's not only additionally devastating for the direct victim, but it's also, in a very powerful psychological way, devastating for those who are forced to experience secondhand what is happening to these others. Mm-hmm. So these are very, and you wonder, is this deliberate, or is it just a coincidental side advantage, if you will, to the perpetrators of the circumstances in which they carry out their crimes? In Sierra Leone, people in some instances would be lined up, and there would be a log or some piece of wood or something, and the perpetrators would bring them up one at a time, and they would ask them to choose, did they want their hand cut off near the hand, or did they want it higher up? And then the people behind would see this happen, and sometimes they'd have to hit them 2 or 3 times, and then that person would stagger off, either to die there or with the hand dangling or no hand. And then the next person would be brought up. So you're standing in line and you're watching this happen, and you're knowing it's going to happen to you. You're knowing it's happening to people that you know, that you've perhaps known your whole life, maybe members of your family. And the cruelty that came through, but also just the very subtle, but as I say, very powerful psychological harm that is being done as these people are brought forward. And we had one man testify who had both his hands amputated, and the reason he had his second hand amputated is that he was captured with his young son, and they were going to amputate his young son. And he said, no, take my other hand. Don't amputate my son. And they did. They took both of his hands, and now his young son helps him in his daily functioning. So the cruelty of that is something that you really, as much as you hear about it, you're perhaps not surprised by it, but I never really could understand it. I never really could understand what would motivate you to do something so cruel as that.
How do you do your job? Given what you've just said, I'm moved to know that the atrocities you've seen and psychological impact on the victims, but on you. How does this affect Brenda Hollis?
You know, I think you do the job because what you see is truly horrific, but there needs to be some redress for that. And that's where I come in, as one of the people who helps to bring about redress. And it's also, it's on a minor way, this is how I can do it. The first long mission we had to Bosnia began in September of 1994, and it was until I think the beginning of November. And it should have been fairly warm, and so we didn't take cold weather clothing. It got really, really cold. And we were in this restaurant that you didn't have hot water and you didn't have lighting most of the time, and you know, you got, every day they did have tomato soup, but it was a different color every day, depending on what they made it from. And so we tried to find some clothing, and then we'd sit around and we'd say, oh boy, this is really bad. And then, you know, we kind of came to a group understanding that, look, we're here for this number of weeks. These people are victims who have survived, or they're survivors who have been secondarily victimized by what happened to others. And this is their life. So how can we complain about it? So these victims experienced that. They survived that. And so how can I say I'm unable to help them get redress? And so that sort of perspective helps you to deal with it. And I think you also deal with it in a way, because as I say, your humanity has to react to this, but at the same time you are a professional, objective observer and assessor. Mm-hmm. And I think that the fact you have to maintain that objectivity also helps with it.
Can you be an investigator and a prosecutor?
Well, we never did that function alone, but we were with investigators. We would ask questions, and in that system we were allowed to do it. And as I say, I think it's important that you have an attorney there. Now, an attorney may be less involved than I was, but there was always an investigator who could come in and testify. So in our setting, to a limited extent, I would not do an interview alone with a witness, but we can, to that extent, be both, yeah.
I guess in a more corporate setting, you would have the attorney reviewing the investigator's work, so there's at least a little dispassion.
Yeah.
If you're on the front line, to be able to do what you've just said is got to be a challenge.
It is a challenge, and that's why I think you have to always, in the back of your mind, know why you're there, what you have to prove. And there are people that they make an impact on you that you will never forget. Mm-hmm. And yet you may determine that you're not going to call them as a witness because perhaps they're not articulate enough to convey what happened, or perhaps what they say may be true, but you can't find any corroboration for it. Mm-hmm. Or you may feel that they are exaggerating things, and so you don't call them as witnesses. So you have to be able to make those decisions, and you have to ultimately go to trial with what you believe, in good faith, you can put forward as evidence, because you are first and foremost an officer of the court, and you always have to act in good faith. And so that means you have to present evidence you believe through a variety of different analyses is credible evidence. So it is hard. And often, when I was doing this in Bosnia, I was not a senior trial attorney. I was a co-counsel eventually in the cases. And there was someone else who hadn't gone out, who had this look at the evidence. And we also did indictment reviews. So we would collect all this evidence, prepare our indictments, and then we would have an indictment review, which in the military we would have called it a murder board, because the objective was to highlight all of the weaknesses, to ask questions, to be sure that we had a good solid evidence and good solid indictment charges. And so that also helped maintain the objectivity of it. And having your elements listed and knowing what your admissibility requirements are, all of that helps. But it is a danger if you also go out on these missions, that you become subjective to the point you cannot be objective. And as soon as you cannot be objective, you can't do your job.
I guess, I mean, even just from listening to what you said of Berkeley, I mean, it's clear that you're passionate about this cause. In reading about the tribunals, you know, there's been some criticism that they're too expensive. Why isn't there military intervention before so that there's no need for these kind of tribunals? What would you say to critics who don't believe in the value of prosecuting an accused war criminal? What's the value in doing that?
Well, the first thing I would say is apply that own philosophy to your hometown and say that you'd be willing to forego this prosecution because it's going to cost money. This group in your hometown killed your neighbors, they killed some of your family, they amputated one of your hands, but let's just forget it. Let's just forget and forgive. Well, forgiveness is important for me as a victim or survivor to be able to move forward, but you never forget that. You don't forget you don't have a hand because somebody cut it off. You don't forget that you were serially raped. So if you want to forego accountability in your home, then you can make that argument abroad. But it's a bit of an arrogant argument to say, you folks, you don't deserve accountability, but we certainly would insist on it. That's my first response. My second response is, let's not compare apples and oranges. Let's compare what it cost, if we include everything, the cost of the building, the cost of the equipment, the cost of the vehicles, the cost of the travel, the cost of the personnel. Let's compare a national judicial system that in a year may deal with, let's forget about the number of accused, let's talk about the number of crimes that these accused are being charged with, that deal with tens of thousands, hundreds of thousands of crimes. Let's compare that cost with the cost of these courts. Because you can talk about the number of accused, but you really should be talking about the number of crimes and the number of victims and the period of time over which it happened. And then let's also compare, what did the United States spend in its support for the eventual trial at Lockerbie? And let's count everything again, the buildings, the equipment, the vehicles, everything. What did we spend for that? What did we spend for Oklahoma City? And think this is one isolated event, one day with just a couple of accused or three. So once we begin to be more comparative with things that come close to that, I think we begin to understand. Now, could these international courts have operated more efficiently? You can always operate more efficiently. And do they have a duty to operate more efficiently? Yes, they do. They have a duty to operate more efficiently. They have that duty to victims and survivors. They have that duty to accused persons, and they have that duty to those who fund the operation of these courts. So that would be my response to that.
Mm-hmm. David Schaefer, I'm not sure if I'm saying his name right. Schiffer, in his book, we talked about a lot of things, but he talked a little bit about the budget and how small the budget is compared to many other, military operations. When you're out there researching and investigating something like this, and you're on a shoestring budget, how do you deal with that? Like, how do you use the small amount of resources that you have to get the job done?
Well, I think it comes back to efficiency, and also comes back to knowing exactly what you have to prove, what it takes to prove it, and what are the various sources of information. Because, if you're talking about these crimes, you're talking about three categories of proof. Category that we all understand. You have to prove beyond reasonable doubt that these rapes occurred, these murders occurred, etc. Then you have to transform them into the crimes that actually are within the jurisdiction of the court. So if there's an individual murder, that's not within the jurisdiction of these courts. That murder has to be a crime against humanity, a war crime, a genocide. That's another whole set of elements. So you have to understand what it is we need to prove there. And there, you may be able to go to reports, to experts to help you prove some of that. You may be able to ask the judges to basically just judicially acknowledge that there was a conflict, so you don't have to prove it. So there are ways you can try to be more efficient in operating. And when you have a small budget, you need to be more efficient. You also need to be more creative in terms of how do you get personnel resources. And so you might have countries, Canada has been very good at loaning people to these courts. And so that's helpful. But it has to be for a long enough period of time they can actually make a contribution. And then you just have to be sure you know what evidence you've already collected, so you're not sending expensive missions out to gather what you already have. And again, that comes to organization. You have to be very organized, you have to be very knowledgeable about what you still need, and then you have to go about getting it in an efficient way, because your first job is to determine, do we have a case, and if we have a case, to prove that case with your best evidence. That's your first job, not to be the cheapest you can be, but to be the best you can be, the most effective. But then you have to do it as efficiently as you can.
Could you talk a little bit about how your role was different from the Yugoslavia tribunals to the most recent in Sierra Leone? I mean, you said you were a co-counselor, and obviously most recently you were the chief prosecutor. What was different about your role?
Well, for me, there's been, the core role hasn't really been that much different. When I left the Yugoslav court, I had become a senior trial attorney. And when I first went, then I became basically a legal consultant. So when I first went to the Special Court for Sierra Leone, I worked for Dave Crane as a consultant with the experience I had in the international courts in terms of what are the elements, how do we prove them. And then I went out on some of the first missions and again helped to try to keep things focused and organized. Then when I was brought back as the principal trial attorney in the Taylor case in February of 2007, that's basically a senior trial attorney. You're in charge of the prosecution. And then in 2010, when I was selected to be the prosecutor, I continued to be in charge of the Taylor prosecution. So they basically got 2 for 1. So I continued to lead that prosecution, but then I had the additional responsibilities of heading that office. So the only thing different is the additional duties that you have as the head of an office. You have more diplomatic responsibilities. You have overall supervisory and management responsibilities for the office instead of just a team. So it's a broader role with some expanded duties.
Okay, you ready, Dan? Your favorite drink-up song in rugby? I want to know. My daughter was a rugby player, and she used to take me. She was a Kenyan, and she would take Dad. Hey, come, let's go to the drink-up afterwards. And my daughter, I'm thinking, what's this all about? And they'd have rugby shirts, and wow. That's all I could say. So I just want to know.
Well, it would have to be the song of the British select side, "Swing Low, Sweet Chariot." That would have to be my favorite one. Mm-hmm. It's quite sacrilegious. I think if you're very religious, you would take umbrage with it, but that's my favorite.
And I will not ask for the lyrics.
and I won't give them.
I knew that I was surprised. A little bit of a different take. Tonight I'm going to be interviewing the 4 of you, and I think probably this is one of the first times where the 4 of you not only get together, but we'll talk through the Charles Taylor case. Help me to frame the roles of each of them. And David Crane was there at the beginning as the founding, I guess he uses the term, founding chief prosecutor. And walk me through this. So David Crane.
David Crane was, of course, the first prosecutor of the court. So his role was to create a viable office, an efficient office, to carry out our mandate, which for the special court was a bit more selective. They actually have the mandate that is what the international courts can do, and that is to deal with those who bear the greatest responsibility. So he had a more selective mandate, which in some ways made it easier, otherwise didn't. So he had to identify the potential subjects, potential suspects, and then he had to oversee the creation of his investigative capacity, his prosecutorial capacity. And then he had to decide, ultimately, we've gathered all this evidence, here's what my teams tell me about who we have sufficient evidence to indict. Now, I have to decide. And when it came to Charles Taylor, he had to have the courage to say, yes, we have the evidence sufficient to indict this man. And interestingly, David was involved from the beginning in outreach. And he would go out to these different locales, and it was a very interactive outreach, and he would ask them at one point, who do you think bears greatest responsibility for the crimes committed in your country? And virtually all the time, they said Charles Taylor. So he had the courage to convict, or to indict Charles Taylor. And then he had the courage to go out to another country when Charles Taylor left Liberia to say, please give him to us. And it was the courage that was expected of him as prosecutor, because as a prosecutor, you act independently of any of this political stuff. And he did. So that was him. He got us going. He made the ultimate decisions about who we would indict, including having the courage to indict a sitting head of state, who was very, very powerful in that area, and to then try to use legal means to have him transferred to our custody.
You were involved in, as a consultant to David at that time in working on the indictment?
Yeah. I was involved in the initial indictments, the initial investigations, initial indictments. And there was never a conflict in our office about should we indict him or not. As soon as we evaluated the evidence that we had, he was clearly someone that we should indict. We had other discussions in our office about people that did not end up getting indicted. But Charles Taylor was always, it was clear to all of us working on that case, building that evidence, that this man was one of those who should be indicted.
Other heads of state?
Those weren't the ones that we had the arguments about. The arguments about were really those who were lower but had been involved in notorious crimes that had an impact on a large number of victims. So that was Dave. What a crucial role he had. Desmond De Silva was there at the same time as the deputy prosecutor. Yeah. And then Desmond stepped in. And it was his job eventually to reevaluate the evidence that we had against Charles Taylor, to work to try to secure his transfer to the court. And if we had, work hard to try to secure that transfer. And in fact, in 2006, he asked me to come back to the special court, and I spent most of 2006 evaluating the evidence, saying, yes, we do have enough. Maybe we should amend the indictment to have fewer charges, would still be reflective, and helping put together the initial disclosures. So Desmond
as a consultant?
As a consultant.
Right.
So Desmond used his skills to assess where we were at. And once he was satisfied that we had enough truly to go forward with an effective prosecution, to use his skills diplomatically to try to get the Mr. Taylor transferred to us. And how critical that role was, and how well he performed that, just as Dave Crane had so well performed his role. And then Stephen Rapp came on board at the time that we were in the final stages of preparing to prosecute
Where did he come
Charles
from?
Taylor.
Steve, was he on?
He was at ICTR. He's at the International Criminal Tribunal for Rwanda. Okay. And so he came, and Stephen Rapp is a dynamic man, as are both Desmond and David. And Stephen is a very, very knowledgeable and skilled prosecutor, lots of hands-on experience, just as Desmond De Silva had. And so he actually helped us with a lot of the questions that we weren't clear about. So we would have discussions. I would say, I want to do this about this witness or this issue.
At this time, you're now on staff.
Not yet. He brought me on. He came on, I think, the end of 2006 and brought me on February of 2007. So throughout the trial, we would go to Stephen and would say, we got this issue. I think this, this, my second chair, if you will, my next senior attorney, very skilled. I respect his opinion. He's not so sure. So we would talk with a lot of tactical things with Stephen. And Stephen took two of our witnesses, the former vice president to Charles Taylor, and for some 2 months, president of Liberia, Moses Blah. Stephen led his evidence. And then we called our evidence custodian, and Stephen led his evidence as well. And Stephen also played a critical role in keeping the funds flowing for the court, because it was a critical time in terms of funding for the court. So again, what a critical function he performed. And we had, when Stephen left, and before the next prosecutor was chosen, we had an acting prosecutor, Joseph Kamara, who kept things on an even keel, kept us moving forward, again, helped with the fundraising. And he was someone that I also would talk with about tactical decisions in the case. So everyone had fit in at a different point in time in the development of this case, and basically performed a very critical role for that particular point in time.
Tell me about the continuum. I mean, you're the senior trial counsel. You brought in February of 2007, so you're in the courtroom. You're that point person, and I realize that variously other people might do the questioning, et cetera, but you're the person. You're the thread throughout. Whether it and that, I assume, was a very critical. I'm asking you, but a critical component that there was that continuum throughout that trial is Brenda Hollis, and there's senior trial counsel and ultimately chief prosecutor, because you then took that on to the conclusion. Did you find that? Well, let me just be very wonderfully congratulatory. Many people I've talked to, including Jim Johnson, said Charles Taylor is Brenda Hollis's trial. Now you're going to deny that, but because you were at the beginning, the indictment, and through the process, do you feel that sense? I mean, this has been a long trial, but now it's coming to closure.
You know, I don't feel that sense, and it's not a false sense of modesty, but these trials are the result of the work of so many people, and the conduct of the investigations, the development of the indictment, the pretrial activity, the course of the trial itself. And so it's good to have sort of a continuing influence with a vision of the strategy, and to be sure that we stay online with that strategy, or to be able to adapt it depending on how the evidence comes out. But the success of a trial is always because of the many, many people who are so skilled and talented and dedicated. So this wasn't, Charles Taylor trial wasn't Brenda Hollis at all. Charles Taylor trial was the investigators, the support personnel, the attorneys that I was so privileged to work with, the former prosecutors who brought it so far, Stephen Rapp, who helped us throughout. It is a team effort, and it must always be seen as a team effort. So again, it's not a false sense of modesty, it's simply a good grasp of reality that leads me to say that no, it wasn't the Brenda Hollis trial. It was a team effort that led us to put on a very effective case. And it was also the courage of witnesses to come forward and give the judges the information they needed. Mm-hmm. And that's true of all of these trials at the international level. Now, if there are failings, as the senior trial attorney, as the head of the office, those failings you own. That's part of your job description. Mm-hmm. Mm-hmm. You may go out and everybody wants to interview you, but if it goes wrong, it's you, because either it was your decision, and ultimately they all are your decisions, or you did not take appropriate action for a decision somebody else made. Mm-hmm. But when it's a success, it's always a success because of each person who adds a little bit to that overall picture.
When you're announcing the verdict, did you have any? Were you tipped off as to what the game was?
Oh no!
So you're listening.
Despite what has been out there, all you had to do is really watch that trial to know that we weren't the darlings of those judges, and we weren't tipped off at all. I had two scenarios to prepare for my press conference afterward. One was a full acquittal, and one was conviction on some or all counts, because we had no idea. Mm-hmm. And you're on tenterhooks in there. And then especially when they were saying, oh, you didn't prove this, you're thinking, oh my goodness sakes. So no, we didn't know. And the one thing I told the team is, no matter what they say in there, you cannot throw up. So no, we didn't know that at all. If the accused voluntarily absents himself and does not give direction to his counsel, but then they have to basically be appointed to ensure the fairness of the trial. So those scenarios were averted because of his speaking with his attorneys and mostly being present at trial. And Charles Taylor is he can be a very charming man. He's a very intelligent man. You can understand how he reached the positions that he reached. So it was interesting in court to see him, and during his testimony in chief, which lasted for months and months, it was very interesting to see him.
Oh, really quick, there's a woman named Maria downstairs that said you're supposed to meet at 11:15.
Oh,
11:30. So I
yes.
didn't want to interrupt, and I kept like,
yeah.
So
Okay.
yeah.
Or should we continue? Should we just?
We're also losing a lot of light in that room, so it'd be great to like maybe. I don't
Sure, you
know.
can do whatever you want. We may pick this up later, because I'll have to talk about Milosevic and Karadzic, and
Yeah.
you're such
Yeah,
a
ask
talent.
them
You're
if
such
Well-
a wealth of
Upstairs.
knowledge.
I'm just
Plus you're gonna
that just translates into being old. I've been around a long time.
Well,
There was
we're of a similar age. Watch where you go. To the sun.
I think we're better off if I don't.
You were being involved with the International Criminal Tribunal for Yugoslavia, and the names that we constantly hear, the three big names, and ultimately now they've either been captured in the process of being tried. I wonder if you could give us an impression. I'm just going to give you names and maybe just give us an impression of the three, and we'll start with Milosevic. What was your sense of him, his criminal activities?
A bully and a thug. A very powerful man, but in essence, I think a bully and a thug.
When he decided to do the trial by himself, what was going on, and within the prosecution staff, this must have been pulling out your hair because of just.
Of course, I wasn't there. I had left by the time they got him. But when you have a situation like that, you have to be alert to try to keep things in court focused on what's relevant and what's not relevant. And one of the things that happens with people like this is that it becomes a political forum for them, which is exactly what it became for him. But you need to keep it focused on the elements of the crimes, elements of responsibility, all of those things that are legal, they're not political. And so you need to be sure that what you're there to prove doesn't get lost in the mix. You also need to be concerned when somebody decides to represent himself or herself. It almost puts an additional burden on the prosecution because you have to protect the record on appeals. You have to make sure that nothing seriously unfair is allowed to happen because this person's representing himself. So it puts an increased burden on you to ensure that this record will withstand appellate scrutiny. So I'm sure those were things they were thinking about in various ways as he was presenting his case. And the other thing, of course, is that when it becomes a political message, you don't really know exactly what it is that you may have to rebut here. So you have to be very attentive to make sure that in your examination of their witnesses and your examination of them if they testify, that you focus back on how you're proving your case to make sure that there isn't something that's been raised in a political context that may impact on your burden of proof to prove these crimes, these modes of liability beyond a reasonable doubt.
Karadzic.
Smart. I think very clever man. Very good, I think, at the use of propaganda. Very devious man, I think.
Mladic.
Very, very much the Serbian general. I think probably very straightforward in many ways. I think also probably a lot of elements of the bully, the thug.
When you investigated in Serbia the crimes, and you were raising the question of who are the most responsible. Were those the three names that jumped out?
Well, you know, at the beginning, and the mandate for the ICT1 and the ICTR was that you shall prosecute those who committed serious violations of international humanitarian law. Well, you're talking about tens of thousands of people.
Right.
So you had to, of course, at the very beginning, have an idea about what was the structure. How high up might the criminality go? And there was enough information there to know that the structure certainly went up to Karadzic, certainly went up as a potential, it would depend on the evidence, went up to Milosevic. Mladic, because of the notoriety of the siege of Sarajevo and other things, another possibility. So they didn't have that restricted mandate. We didn't have that restricted mandate. So we didn't automatically think that, although those would have been in our scope as potential suspects, depending on how the evidence developed.
In the Milosevic trial, since part of the prosecution's case was put into evidence before he died, what happens to the evidence that has been gathered for the prosecution of the trial that wasn't actually submitted? Can you do anything with it?
Well, actually, I think we had submitted our evidence. I think they were moving into the defense phase, or perhaps even in the defense phase.
Okay.
But the evidence that you have very often is relevant to other cases as well. So depending on where the crimes were committed, the evidence against Milosevic, a large part of it could have been relevant to the trial of Karadzic, the trial of Mladic. So you have a lot of commonality among that evidence. You sort of, you're working your way up, if you will, a chain of command. And you may find that Karadzic, Mladic interfaced a lot with Milosevic, so that you were building on the same evidence, and then you would just have some specific to those particular accused. So you had a lot of commonality in the evidence that you would be using in other trials, or maybe even had used in previous trials. So
Therefore not lost by the mere fact of his death.
that's correct.
On the prosecution side, the term, I guess, the founding prosecutor, Richard Goldstone, what was he like?
A very genteel man, very accomplished man, very sensitive to the fundamental human rights that had been violated by these crimes. And he was, I think, the man that we needed at the time. He was able to basically put the court on the map, to work in different arenas, to make it known that we were there, that we were moving forward, to gain some cooperation for us. So very much the one to build bridges, to set the foundation for us to be able to do our work. But a man for whom I have a great deal of respect.
Normally he's here. I know that you got a schedule conflict. Also, there's a Jackson Connect. I'll tell you that. And there's a point how he got appointed. Louise Arbor.
A brilliant woman, insightful woman. We would have issues. We had weekly meetings where we would talk about legal issues that came up, procedural issues, or we would have an indictment review, and we'd be at an impasse. There'd be this group that said this and this group that said that, or we'd be talking about this legal construct and how do we use it. Again, we'd have a division. We'd go to Louise and we'd say, here it is, and she'd say, boom, 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 and that would be it. It would be like, of course. So very dynamic woman, very personable, but again, very, very brilliant, very insightful legal mind that really helped us to steer a very steady and I think right course during the time that she was there.
Carla Del Ponte.
Strong woman, kind of a in-your-face, smash-mouth football kind of woman.
Mm-hmm.
But again, I think was who we needed at the time. We needed information we weren't getting, despite what we had been asking for. And she came in, and it was like, we're going to get it, and that's the way it is. Very forceful, pushing forward to kind of push through the obstacles that Louise had not been able to finesse. And so again, I think we're very fortunate to have the right woman at the right time in that position.
External politics became a part of the story of the Karadzic and Mladic arrests. Did you see much of that while you were there? The efforts of the tribunal or the prosecution to get the political process to find out, locate, try to assist in the arrest part, the enforcement part of this?
You know, from the very beginning, these courts rely on states and the international community to actually apprehend people, transfer them, to give us access to information, to witnesses, to crime scenes. So from that point of view, you have to deal with outside authorities to get the access you need to complete your mandate. So that was true from the very beginning. And there was a constant movement once we indicted people to try to get states and the international community to live up to their obligations. Because, of course, for the two ad hoc courts, the ICTY and the ICTR, they were Chapter 7 creations of the Security Council, which meant that, in theory, every member of the United Nations had a duty to comply with orders of the court, to comply with requests of the court. Now, from a practical point of view, unless you can enforce that obligation, doesn't mean much. And the enforcement was for the president of the court to complain to the Security Council, and then it became a matter of political will. So we always had to deal in that environment, not to decide how we were going to investigate, what we need to prove, who we're going to indict, but how do we get access to what we need? How do we get access to our indictees? That was true from the very beginning. And I think when Carla came in and then with Serge Brommertz, it was simply a matter of trying to push through the barriers we hadn't been able to push through before. And perhaps as time passes, it makes it easier for a state to turn someone over as well. Because they've been out of sight and out of mind for a while. But it was a process we had to go through from day one.
It seemed like certainly in the Yugoslavia, at least those two individuals, the political will coincided with their interest in becoming accepted into the European Union. I mean, there was dynamics going on here.
Yeah, and there are dynamics all the time.
Yeah.
It's very interesting that I think for the Rwanda tribunal, they actually got a lot more cooperation from states and being able to get people. They have a few people, I think, now that they've been unable to get, but there wasn't such the high drama in getting them as there was with a lot of these more high-profile people in the Yugoslav court. But you use whatever leverage you have. And again, it's not a matter of saying, if you promise to do this for us, we won't charge this person or we won't charge this crime. It's a matter of saying we have an indictee, we want that indictee, you want this, and having other states and international organizations work with you to exercise that leverage to hand over somebody who's been indicted. So I think that's the level at which this kind of political interface becomes critical.
You're here today at Chautauqua. We're thrilled to have you here, Brenda. What do you hope to get out of these next couple of days? As you accepted the invitation coming over here, is there expectations?
Well, I hope to...
Other than seeing your brick...
my brick.
Yeah, I mean, you're on the Walk of Fame. You may... this not everybody gets there, and that's the only...
Has that brick already been...
It's there.
Oh, too bad, because I always use my middle initial.
Oh, is that right? Well, we can correct that. The beauty of a brick, we can check that.
Now, I've been accused sometimes of being as thick as a brick, so maybe it's appropriate that I have a brick.
Yeah, so when just ironically, Fatu's been here when annually we have a sort of a ceremony of the laying of the new chief prosecutor's brick, and Fatu's viewed this for the last 4 years, and last year was more knowing the game was afoot. maybe someday you'll be looking, and our email to her congratulating her was simply, "We are preparing your brick." And she was quick to point out, "That's why I'm here, to see this."
But what I hope to gain from my time here, in addition to interacting with many people outside of this very small number of prosecutors of these courts, interacting with others who've been instrumental in moving forward this idea of international accountability and international courts, is to do something that attorneys don't always do very well, and that's to listen very attentively to the remarks of others who have been leaders in these courts, have perspectives and experiences that I may or may not have heard before. So I want to listen and absorb their thoughts, their perspectives, their ideas.
What's the timeline here for the Sierra Leone Tribunal? You have certainly last case, Charles Taylor. You're on appeals. There'll be other. The process will sort of continue, but it's definitely winding down. What are the plans right now for the legacy aspects?
Well, first of all, in terms of the time frame, we are expecting a judgment, a final judgment in the Taylor case, the appeals judgment, the last quarter of next year. With that judgment, it's almost certain that that will be our last case. We have one outstanding indictment against Johnny Paul Caroma, who was the chairman of the Armed Forces Revolutionary Council. Our evidence is he's dead, he was killed. It's unlikely he would surface before the termination of the Taylor case. So it's likely that Charles Taylor will be the last accused we'll try. Very soon after that appeals judgment, the special court will close and a residual court will stand up in its place that would have the ability to try Johnny Paul Caroma if he's alive and he's found, if the case is not handed off to a state to try him. So the timeline for the likely closure of this court and the standing up of the residual court is the last quarter of next year. In terms of legacy, that will really be for the people of Sierra Leone and Liberia and the international community to decide. But for me, the legacy is how well did we do what we were mandated to do? Unfortunately, a lot of expectations are placed on these courts that have nothing to do with their mandate or their resources. And then they're judged in terms of those functions rather than their core function. So to me, the legacy will be that the Special Court for Sierra Leone did what it was mandated to do. It identified those individuals who bore the greatest responsibility for the crimes. After investigations and the approval of indictments, they were tried. They were given fair trials, trials at which witnesses and victims were treated with dignity and heard with dignity. So there was a rule of law applied to accountability. And we did the job we were asked to do. To me, that is the key legacy. And we did it in a way that should be emulated by other courts, national courts. That is, we gave a fair trial to these accused. No matter how widely it may have been believed in that country that they committed these crimes, the prosecution, quite rightly, had to prove it beyond a reasonable doubt. They were given the opportunity to present defenses. They were given the opportunity to appeal. The prosecution also was given the opportunity to appeal. So the rule of law was used instead of the rule of the gun to determine accountability. I think that's a very important legacy. Because of the dynamics in place in Sierra Leone, this court was actually able to be headquartered in that country. Rwanda wouldn't let the ICTR be in Rwanda because we didn't have the death penalty and there were some other things they didn't like. ICTY, there was a hot war still going on, and so it was that court was placed outside the country. We were able to operate in Sierra Leone. The government of Sierra Leone always gave us great support, and I think that sort of relationship between the court and the government, and a court being in place because of our circumstances, is also another important legacy for these courts.
this is now for the camera and just an educational opportunity. Charles Taylor was the president of Liberia, a contiguous country. Yet it's a special tribunal for Sierra Leone dealing with those most responsible for the crimes within Sierra Leone. Help the viewer connect the Charles Taylor dot.
Sure. It has to do with the ways in which you can be responsible for crimes. And the way that we're most familiar with is if you directly perpetrate the crime. You kill someone, you rape someone, you enslave someone. But there are other ways that you can be responsible. Even, as was the case with Charles Taylor, if you never directly commit any of the crimes yourself, if you were never in the country. And those ways can be that you gave orders that you either intended by those orders the crimes would be committed, or in giving those orders, you were aware of the reasonable likelihood that when they carried out your orders, they would commit crimes. You can be similarly guilty for planning, either planning something that is inherently criminal, or being part of a plan or devising a plan that you're aware in the implementation of that plan, there's a reasonable likelihood these crimes will be committed. Or for aiding and abetting, providing support that contributes substantially to the commission of these crimes. Again, with the knowledge or intent or awareness that these crimes are likely to result from your contribution. Or as being part of a joint criminal enterprise. We all agree to ultimate objectives, which may or may not be criminal, and the criminal means by which we're going to achieve those objectives. And we each have a different role in that plan, but we are agreed upon that plan. Now, we don't have to sit down in a room and agree to it. We don't have to write down our agreement. You can see that that agreement is in place by all the circumstances before you. So these are ways you can be responsible for the criminal conduct of others. And those are the ways in which Charles Taylor was responsible for the crimes that were committed by the Revolutionary United Front and the Armed Forces Revolutionary Council in Sierra Leone, as well as by Liberian subordinates that he sent to Sierra Leone.
As this draws closure and you have time for reflection, does it ever cause you to pause and say, really, there was a Nuremberg, Robert Jackson continuum in all of this here? What happened in Nuremberg really somehow creates I don't say a shadow, but an influence on what was going on in Sierra Leone?
I think what happened at Nuremberg certainly was an influence in how we reacted to what happened in Sierra Leone. But I think that the influence of Nuremberg was most directly felt when the Security Council created the ad hoc tribunals. And it gave us a basis to say that there are some crimes that are so heinous that at least some level of offender should be held accountable to the international community. These are no longer just a national level. Plus, the states may not prosecute them.
Mm-hmm.
So for a crime that at its core impacts every member of the global community, there should be an international response. And that, I think, comes from Nuremberg. And people talk about Nuremberg as victor's justice. Well, in a sense it was, but the response to that criticism isn't to say we let everybody go free. The response to that criticism is to make sure that even the victors are held accountable to the rule of law and the prohibition against these crimes. So I think Nuremberg lives today, not just in the rich history that it gives us, but it lives today in these international ad hoc courts and in the creation of a permanent international criminal court.
You're going to be going for the first time to the Robert Jackson Center tonight. Does Robert Jackson, when in your studies, whether law school or anything, was that part of the thinking process at all, or what he did there as a prosecutor, opening statement, closing statement, cross-examination? Is that part of the Brenda Hollis world?
It was part of the world in the sense of if you want to see really effective advocacy, there are a few classic examples, and certainly he was one of those examples. So from that point of view, how do you be the best you can be? He was an example of how you could achieve that goal.
Mhm. This is terrific. Just so glad you're here.
Well, I'm very happy to be here.
Now that you find all this Bowling Green connection.
That's right.
and the embarrassment that both David and I again talked about, and John Barrett, because he was there also. I said, we really blew it, and let's not talk too much about this, because we all went and Christoph Safferling. Everybody was sort of this cadre of people interested in what was going on at the Jackson Center, sort of after David's speech, just sort of dished away. And I just looked up online the person who followed David.
Well,
We'll pay close attention. We'll catch up tonight.
I have a healthy ego, but I don't have an overweening ego, so I'm not truly affronted by that.